Let's proceed with Focus on Health Law. This is a presentation of Attorney Kenneth Haber. The moderator here is Attorney Ramesh Khurana. Today, Attorney Khurana questions Attorney Haber on Healthcare Quality Improvement Act and protected professional review activities. Let's see.
This is Ramesh Khurana, attorney at law. I have great pleasure in introducing Mr. Kenneth Haber. Mr. Kenneth Haber, welcome to our studios.
Thank you.
Mr. Kenneth Haber is a former assistant United States attorney and a leading practitioner in the state of Maryland. And we have pleasure that he has come to our studios to answer some of the questions relating to Healthcare Quality Improvement Act. I think this topic is very close to the heart of physicians, and physicians will get a lot of benefit after hearing views of Mr. Kamath. Mr. Kamath, again, welcome to our studios.
Thank you very much, Ramesh.
Mr. Kenneth, Mr. Haber, are you ready to answer my questions?
I'm ready to take a shot at it.
Okay, great. Now, Mr. Haber, how and why are professional review actions encouraged by Healthcare Quality Improvement Act, which you call it HCQIA?
The Healthcare Quality Improvement Act was an attempt by Congress to tailor a remedial legislation that would take in consideration a number of factors that our society has. One is there were doctors jumping from jurisdiction to jurisdiction that would get in trouble in one jurisdiction and be able to go and start practicing in another jurisdiction without any sort of tails following them, without any sort of knowledge following them as far as what they did elsewhere. So that was one factor. At the same time, they were quite aware that doctors are sometimes predatory upon each other, and that they had to establish minimal due process to ensure that a doctor would have an opportunity for a fair hearing in terms of if there was any allegations or charges brought against the doctor. At the same time, they wanted to make sure that there wasn't discrimination against doctors based upon race, national origin, or any of the other type of protected statuses that are encompassed in our civil rights acts. So therefore, people could not decide, well, this person is from here or there, and let's get them because of the fact that we're not. And Congress had to try to balance all these factors, plus many other factors, in coming up with the Healthcare Quality Improvement Act. So they established various protections, and they have a reporting requirement. So if somebody's found to have incurred what's called a reportable event, it'll get reported into what's called the data bank. That's national in origin.
Mm-hmm. That's very interesting. So in order to simplify your presentation, are you telling the audience that now complete records are available for physicians even if they move from one jurisdiction to the other?
Absolutely. It's considered confidential. It's considered protected, but if you're a physician and you want to get privileges at another hospital, you have to sign a consent that will permit that hospital to access the data bank. If that hospital doesn't access the data bank and there's something wrong on your record, they're in trouble. So it becomes a protected, confidential source that there's a mechanism built right in to make sure that everyone who needs to know is going to know.
So can, under SCQIA, is this the self-reporting system by the physician?
It's not self-reporting by the physician, it's reporting by the reporting entities, hospitals, insurance companies, healthcare organizations that have due process, such as your various credentialing boards, if you want privileges or you want status as a diplomat of this or a diplomat of that, of those credentialing boards have due process, then they're required to report.
Oh, that's interesting. I thought maybe self-reporting was imposed on doctors, so that's not the case.
No, it's
Okay,
not the case
got
that they have to self-report.
Okay. Now, Ken, I'm going to ask you a second interesting question. What constitutes a professional review action? Now, that receives protection, and what protection does it receive, and are there any limits as to the protection?
Those are good questions. Those are very good questions. A professional review action that receives protection is one that affords a doctor due process. It's one that provides for him to have an opportunity to present evidence, that he can have an attorney, that he would have a record made, that his peers are not competitors, that he would be afforded a modicum of due process so that Congress would feel that there was going to be justification for the reportable event, i.e. the adverse finding against him, to be reported into the data bank. By the same token, he has these protections. So he theoretically would be able to make a case that this adverse determination should not be found against him. Now, in reality, I find that there's often abuse in the system. Hospitals are economic entities. There are cliques, there are powerful interests in the hospitals, and quite often, not always, but quite often, justice is not necessarily done. So doctors can be found to have violated some sort of standard, have an adverse report where maybe it's not justified. Every case should have to weigh on its own in terms of trying to make that decision as an attorney. The difficulty is all the cases where they follow these due processes are supposed to be reported, and a doctor can be tainted very badly. But at the same time, Congress weighed the situation, made a determination if they provide these protections that the report should be made and go into the data bank, because there's the opposite type of situation where doctors could go off and do malpractice continuously and not have any sort of accountability.
That's very interesting. So Ken, you have explained that theoretically there is a need for the due process, and in fact this is what has been enacted, that due process should be provided to the physician. But in your practice, you see that due process is usually denied?
I wouldn't say usually denied. I would say sometimes denied. I get the cases where people are saying it's denied. They come to me.
Now tell me any interesting case, just in brief, where due process you think that was denied to some extent.
Well, there was a situation where a doctor got fired for certain activities where it forced the licensing board to take a look at him, and the licensing board found that there was nothing wrong with him, but his employer fired him. His employer reported him to the data bank, and the same doctor had no due process afforded to him whatsoever. His employer provided no due process. We were able to get the data bank to go to the employer and say, okay, show us your due process procedures. When the employer wasn't able to do it, the data bank said, you may want to take this report out because of the fact that it's a violation of law. And they quickly took it out.
Oh, that's very interesting. You know, this is how your role could play a significant role in protecting doctors' interest.
That's correct.
Yeah.
Every case you have to look on a case-by-case basis.
Right. Okay. Now, what procedures must be afforded to a physician in order for the protections of the SCQIA to kick in?
Well, as I mentioned, the doctor has to have due process. He has to have the availability of presenting evidence. I go so far as to say that the hospital has an obligation, if it's a hospital setting, to provide all the information that they have on him, because otherwise they're denying him the opportunity to provide that evidence. I've used the due process procedures so as to impose upon hospitals and reporting entities obligations to comply, to go that extra mile to make sure that due process is afforded to these doctors.
Great. Now that leads to another question. Are there any exceptions for the protection as far as the type of suits that are not protected?
Yes. Hospitals are protected from damage suits. They can only be protected if there's compliance, but then they're protected, there's immunity from damages. They're not protected from suits for declaratory judgment. They're not protected from suits for injunctive relief, saying that they didn't comply, saying that they made false findings, other type of situations. However, they are protected from damage suits if they comply with all these things. So it leaves a certain amount of wiggle room in there as to what you can sue for. Now, if there's discrimination, if you can show there's discrimination, they have no protection. If I can file a suit against them, if there's grounds for filing a suit against them for discriminating against a doctor because of national origin, because of religion or whatever, then if in fact a court were to determine that's the case, then that hospital would be in a lot of trouble and a big damage judgment against them.
So then I'd like to ask you a question. When you are saying that when there is a discrimination case, you could ask for the damages. My question is whether you could ask for both compensatory and punitive damages or just compensatory damages?
You can ask for punitives, like under any sort of discrimination suit, yes. If they've discriminated, the statute provides them no protection whatsoever. It becomes a question of fact for a court to make a determination of eventually, in the law. So the hospitals are not without some accountability in these situations.
Can you please explain for the benefit of the audience what are equitable suits and whether these are prohibited or these are not prohibited?
Equitable suits are not prohibited, only damages. So if a doctor feels that, let's say he doesn't have any status to claim civil rights protection, but he feels that the hospital made a wrong decision and that they need to adjust the data bank, you can sue for equitable declaratory relief and convince a court that that's the case, and the judge certainly can issue an order to the hospital to withdraw that report.
Ken, great. I think we are being indicated that time is over. Otherwise, I can go on and ask you questions because your responses are so appropriate. I love them, and that shows the kind of experience you have in the field. And Ken, thank you very much for coming to our studios. I'm pretty sure that our audience has been greatly benefited. So do you have any last word for the audience?
Yes, I would like to say and quote colleague of mine that if they have any questions about these type of issues, they should see a good healthcare attorney.
Thank you very much.
Thank you.
I appreciate you coming over here.
My pleasure.